Did you know that if your child receives any type of derivative government benefits, that amount must be included in your child support worksheet? And that if that amount exceeds your total child support obligation, you could have your child support set at $0 retroactive to your disability? Hi, I'm Stephanie Hunnell, the owner of the Hunnell Law Group in Asbury Park, New Jersey. And I have been practicing family law attorney for nearly 2 decades. And I wanted to take this opportunity to congratulate my team on a really hard fought victory for one of our clients. Our team fought for nearly 4 years to secure a six-figure judgment representing overpayment of child support. That included a summary judgment motion, a trial, and an appeal. And after all of that time, we finally secured a judgment for overpayment of child support. The really cool thing, in my opinion, is that in granting our request and denying the appeal, both the trial court and the appellate division cited a case that I participated in and was involved in 15 years ago, which confirmed that there's an exception to the anti-retroactivity statute in New Jersey. Which allows the retroactive modification of child support beyond the date that you file your application. So I just wanted to take that brief moment to say how proud I am of all of my team at the Hunnell Law Group. So in New Jersey, the statute, anti-retroactivity statute, says that child support cannot be terminated retroactive beyond the date that you file your application for reduction or modification. Now, despite the statute, we were able to successfully reduce my client's child support going back to 2009. And again, in doing so, we secured him a credit for his overpayment of a six-figure amount. Why did this happen? So, in addition to emancipation, which is allowed to be a retroactive modification, whenever a child receives derivative benefits, that is also an exception to the anti-retroactivity statute, and you're entitled to relief going back to either your date of disability or the date that you filed your first application. In our case, the appellate division confirmed our argument, which we made throughout the entire process, that because our client filed an application in April of 2009 and again in 2010 on his own, requesting the modification of support based on his disability, that he was now entitled to relief, even though we were coming into court in 2019 to seek that modification. The court upheld our argument that if they didn't apply the credits, that would have been a windfall to the other parent. The reason is the person was receiving child support and the derivative benefits. So they essentially were receiving two payments of child support. And in New Jersey, normally they really err on the side of permitting children to continue to receive that amount of support without it being retroactive, because they don't want to take money out of a child's mouths, so to speak. But in this instance, they really confirmed that those payments were not a gratuity. The payments were not already used by the child. They were actually a double dip and a windfall to the other parent. So there is an opportunity in the state of New Jersey, despite the general consensus and statute, that you cannot get child support reduced retroactive to the date of filing, beyond the date of filing, excuse me. But these are the two exceptions: emancipation and disability when the child is receiving a derivative benefit. So if you have any other questions, I am going to post a link to the actual case if you wanted to review it and get some more information, or you can always call the law firm. We're here to help. Thanks.